Good day, future lawyers. I hope you're all doing well. So for today, let us discuss about forcible entry and unlawful detainer under Rule 70 of the Rules of Civil Procedure. Let's begin. The actions for forcible entry and unlawful detainer belong to the class of actions known by the generic name action interdictal or rejectment, where the issue is the right of physical or material possession of the subject real property independent of any claim of ownership by the parties involved. What rules will govern? All actions for forcible entry and unlawful detainer are governed by the rules on summary procedure. They are summary in nature, intended to provide an expeditious means of protecting actual possession of property. Thus, lest the purpose of these summary proceedings be defeated, any discussion or issue of ownership is avoided unless it is necessary to resolve the issue of de facto possession. Now, which court has jurisdiction? Forcible entry and unlawful detainer cases are within the exclusive original jurisdiction of the Metropolitan Trial Court, the Municipal Trial Courts, or the Municipal Circuit Trial Courts. Note that this jurisdiction is regardless of the amount of the claim for damages or unpaid rentals sought to be recovered. This is provided for under Section 33, Paragraph 2 of BP Bilang 129 as amended. As for venue, actions for forcible entry and unlawful detainer shall be commenced and tried in the municipal court of the municipality or city wherein the real property involved or a portion thereof is situated. Moving on, let us identify the distinctions between forcible entry and unlawful detainer. First of all, under forcible entry, possession of land by the defendant is unlawful from the beginning as he acquired possession of the property by force, intimidation, strategy, threat, or stealth, otherwise known as fists. On the other hand, in unlawful detainer, possession is initially lawful, but it becomes illegal by reason of the termination of his right to possession of the property under his contract, whether expressed or implied, with the plaintiff. Another distinction is that in forcible entry, the 1-year period within which to bring the action is generally counted from the date of the actual entry on the land, while in unlawful detainer, the 1-year period within which to bring the action is counted from the date of the last demand. In forcible entry, plaintiff must prove that he was in prior physical possession of the premises until he was deprived thereof by the defendant. Plaintiff in unlawful detainer need not have been in prior physical possession of the property. Note that in forcible entry, no previous demand for the defendant to vacate the premises is necessary, while in unlawful detainer, demand is jurisdictional, as provided for in Section 2 of Rule 70. Consequently, the importance of demand in unlawful detainer cases cannot be overstated, as it is provided for in Section 2, Rule 70, lessor to proceed against lessee only after demand. Unless otherwise stipulated, such action by the lessor shall be commenced only after demand to pay or comply with the conditions of the lease and to vacate is made upon the lessee, or by serving written notice of such demand upon the person found on the premises, or by posting such notice on the premises if no person be found thereon, and the lessee fails to comply therewith after 15 days in the case of land or 5 days in the case of buildings. In other words, compliance with the jurisdictional requirement concerning previous demand is a prerequisite to establish a cause of action for unlawful detainer. Moving on, Section 12, Rule 70 provides for referral for conciliation. Cases requiring referral for conciliation where there is no showing of compliance with such requirement shall be dismissed without prejudice and may be revived only after that requirement shall have been complied with. The local government code establishes the general rule that the lupon of each barangay shall have authority to bring together the parties actually residing in the same city or municipality for settlement of all disputes. Hence, if both parties live in the same city or municipality, they are required to refer the case first to the barangay for the possibility of reconciliation. In case of failure to compromise, the punong barangay may issue a certificate to file action accordingly. What must be alleged in the complaint? For forcible entry, that plaintiff had prior physical possession of the property, that the defendant deprived him of such possession by means of force, intimidation, strategy, threats, and stealth, that the complaint was filed within 1 year from dispossession. And for unlawful detainer, the following must be alleged: that initially possession of the property by the defendant was by contract with or by tolerance of the plaintiff. Eventually, such possession became illegal upon notice by plaintiff to defendant of the termination of the latter's right of possession, that thereafter the defendant remained in possession of the property and deprived the plaintiff of the enjoyment thereof, and the plaintiff instituted the complaint for ejectment within 1 year from the last demand on defendant to vacate the property. What determines the cause of action is the nature of defendant's entry into the land. If the entry is illegal, then the action which may be filed against the intruder within 1 year therefrom is forcible entry. If, on the other hand, the entry is legal but the possession thereafter became illegal, the case is one of unlawful detainer, which must be filed within 1 year from the date of the last demand. Upon examination of the allegations in the complaint and the evidence attached thereto, the court may dismiss the case outright on any of the grounds which are apparent therein. However, if no ground for dismissal is found, it shall forthwith issue summons. Thereafter, the defendant shall file his answer within 10 days from the service of summons. Affirmative and negative defenses not pleaded therein shall be deemed waived, except lack of jurisdiction over the subject matter. Cross-claims and compulsory counterclaims not asserted in the answer shall be considered barred. If the defendant fails to file an answer to the complaint, the court, motu proprio, or on motion of the plaintiff, shall render judgment as may be warranted by the facts alleged in the complaint and limited to what is prayed for therein. As mentioned earlier, the municipal courts exercise exclusive original jurisdiction over cases of forcible entry and unlawful detainer. When, in such cases, the defendant raises the question of ownership in his pleadings, and the question of possession cannot be resolved without deciding the issue of ownership, the issue of ownership shall be resolved only to determine the issue of possession. Essentially, while an ejectment case merely settles the issue of the right of actual possession, the issue of ownership may be provisionally passed upon if the issue of possession cannot be resolved without it. Any final disposition on the issue of ownership, however, must be resolved in the proper forum. This is because the only issue to be resolved in an ejectment case is physical or material possession of the property independent of any claim of ownership by any of the parties involved. Hence, the assertion by the defendant of ownership over the disputed property does not serve to divest the inferior court of its jurisdiction. The defendant cannot deprive the court of jurisdiction by merely claiming ownership of the property involved. As enumerated in Section 13 of Rule 70, the following are the prohibited pleadings and motions. The reason for this is that forcible entry and unlawful detainer are governed by the rules on summary procedure to provide expeditious remedy and protection relating to material possession of the property. Please note that the court may grant preliminary injunction in accordance with the provisions of Rule 58 hereof to prevent the defendant from further committing acts of dispossession against the plaintiff. A possessor deprived of his possession through forcible entry or unlawful detainer may, within 5 days from the filing of the complaint, present a motion in the action for forcible entry or unlawful detainer for the issuance of a writ of preliminary mandatory injunction to restore him in his possession. Section 18, Rule 70. Judgment conclusive only on possession, not conclusive in actions involving title or ownership. The judgment rendered in an action for forcible entry or unlawful detainer shall be conclusive with respect to the possession only and shall in no wise bind the title or affect the ownership of the land or building. Such judgment shall not bar an action between the same parties respecting title to the land or building. The resolution of the municipal court on the ownership of the property is merely provisional or interlocutory. Any question involving the issue of ownership should be raised and resolved in a separate action brought specifically to settle the question with finality. Finally, appeal. The judgment or final order shall be appealable to the appropriate regional trial court, which shall decide the same on the basis of the entire record of the proceedings had in the court of origin and such memoranda and or briefs as may be submitted by the parties or required by the regional trial court.